I wanted to provide you with a video summary of some topics that maybe need some additional attention or explanation based upon the performance I saw on the exercises that I've graded so far. And of course, this is information that is essential for you to be able to perform well on your first exam. So let's go back for review purposes and address mainly the topics of parties to civil litigation and jurisdiction and venue. Let's start with parties. When you are considering who the typical parties are to a civil lawsuit, obviously it is the plaintiff, the party or person bringing the lawsuit, and the defendant, the party or person defending the claims that are brought by the plaintiff. However, there are some general concepts that you also need to be thinking about as you're deciding who is a proper plaintiff and who is a proper defendant. Remember the concept of standing that we discussed. A plaintiff must have standing, meaning they must have a stake in the outcome of the litigation. When you're considering who that plaintiff must be or who the defendant must be, the concept of a real party in interest comes into play. And that means a person or an entity who has the right the lawsuit seeks to enforce. And remember, we talked in class about the difference between suing a driver versus suing the driver's insurance company in a typical car accident case. And generally speaking, the driver is the real party in interest, even though the insurance company may be providing the defense to the lawsuit and or paying any judgment that is rendered. Obviously, you can have a corporation that is a plaintiff or a defendant, and you just need to be sure that the corporation is acting through an authorized officer, whether they're filing a lawsuit or answering a lawsuit. And from a service perspective, be sure that the appropriate party is actually receiving service of notice that the lawsuit has been filed. And then we talked briefly about joinder of parties, and this is triggered by Rules 19 and 20. Certain parties must be included in the litigation in order to resolve all issues that arise out of the same set of facts. So Rule 19 talks about a party who should be joined if that party's presence is required to grant complete relief by the court. And Rule 20 is a party may be joined if there's a common question of law or fact. I want to move into certain special situations in which there are counterclaims or cross-claims filed. Remember, a counterclaim is a claim that's filed by the defendant against the plaintiff. A cross-claim is filed by one defendant versus a co-defendant. And then third parties may be brought in by either the plaintiff or the defendant as discovery proceeds if, again, their presence in the lawsuit is necessary to fully adjudicate all of the claims being made arising out of the same question of law or fact. There's also such a thing as a class action. In that situation, multiple parties will be joined in a class action lawsuit seeking relief from a particular defendant. These are typically what we call mass tort cases, where there is a common illness related to either illness or injury related to either a certain type of manufactured product. A lot of the breast implant litigation was in the form of a class action lawsuit. A lot of the lawsuits against Toyota were eventually made a class action lawsuit where all the plaintiffs had a common claim and injury against a particular defendant. And again, to save court resources, the combining of those claims into a class action is deemed prudent. So let's talk about the what of the litigation, and specifically, is there a case or controversy? Remember, we talked about in class that in order to file a claim, it must be ripe for adjudication, meaning it has not already been resolved in some other fashion, or you're not seeking an advisory opinion from the court as to what it would do if certain facts occurred that have not already occurred. You must walk yourself through the process of identifying the subject matter of the dispute, the parties and their locations and residences, and if there is any property, real property or personal property involved in the litigation, where is that property located? And these are all relevant to your decisions as to jurisdiction and venue. Jurisdiction, by its easiest definition, is the court's authority to hear a particular case and decide it on its merits. In deciding jurisdiction, the first thing that you have to do is decide whether or not the case must go to federal court as a matter of exclusive jurisdiction, to state court as a matter of exclusive jurisdiction, or whether or not the state and the federal courts share jurisdiction under the concept of concurrent jurisdiction. And then venue relates to the actual physical location within the state or federal system where the lawsuit would be filed. So let's go back and talk about the types of jurisdiction that courts have. The first is subject matter jurisdiction, and we're going to talk first about what cases are the exclusive subject matter jurisdiction of the federal courts. The first category of those cases are cases that deal with federal questions under 28 U.S.C. 1331. Federal questions are things such as civil actions arising under the United States Constitution, civil actions arising under federal law, or civil actions arising under treaties. And those would all go to the court of general jurisdiction in the federal system, which are called the U.S. district courts. Another type of category that is the exclusive jurisdiction of federal courts are federal questions relating to very specific types of matters, such as bankruptcy or admiralty. These are also federal questions, but they're very specific subject matters, so those go into the court of specific jurisdiction as opposed to the court of general jurisdiction in the federal system. Then there's a concept of pendent jurisdiction, and this allows federal courts to adjudicate cases that are not federal claims. And the court can try these non-federal claims with federal claims if it's derived from the same common set of facts, but that's the only situation in which that may occur. Another category of cases that are the exclusive jurisdiction of federal courts is when the United States or some agency or entity thereof is actually a party to the litigation. Although in a lot of these cases the federal entities are protected from suit by sovereign immunity, which protects government agencies from being sued when they are functioning in their official capacity. However, certain federal government agencies may consent to lawsuit under the Federal Tort Claims Act. Another category of cases that are the exclusive jurisdiction of federal court are cases where U.S. agency is a party. And then finally, a situation of diversity jurisdiction where there is citizenship of different states, and that has to be on each side of the litigation. So the plaintiff must reside in one state and the defendant must reside in a different state or foreign country. And then you also have to have an amount in controversy that exceeds $75,000. So those are two things that must be present in order to have diversity jurisdiction. In this situation, diversity jurisdiction does not grant exclusive authority to the federal court, but it grants concurrent authority with the state court system. In the case of diversity jurisdiction, the plaintiff generally has the option of filing in state or federal court. And depending on the plaintiff's decision in that regard, the defendant may ask for removal. If the plaintiff chooses to file a situation of concurrent jurisdiction where there's diversity and the appropriate damage amount in state court, the defendant may opt to remove that to federal court. However, that removal transaction cannot occur in the reverse, meaning if the case is filed in federal court, it stays in federal court. The notice of removal must be filed within 30 days of service, and it is an automatic. It's not something that has to be asked for and granted by the state court or the federal court. The second type of jurisdiction is in personam jurisdiction, or jurisdiction over the person. So in addition to having subject matter jurisdiction based upon diversity or federal questions or the other matters that I just mentioned, the court must also have personal jurisdiction, or the power to bring a party before it in order to bind that party to a judgment. There's general personal jurisdiction, which a defendant can be sued on any personal matter, and then there's specific, where the defendant may only be sued if claims arise out of specific contacts the defendant has with the forum. And then there's also the concept of a long-arm statute, which every state has, which essentially allows the states to go beyond their geographical borders to bring a defendant into the state to adjudicate an issue. There's also the concept of in rem jurisdiction, and this is when property is located within the state where the court sits and in which the parties have their dispute. And jurisdiction over the party exists merely because of this ownership of property within the state's jurisdiction. And the courts decide the right in the property, and the decision is binding on anyone with an interest in that property. This is contrasted to quasi-in rem jurisdiction, which allows the plaintiff to use the property of the defendant to satisfy a claim so long as the property is in the state. There's no requirement that the defendant is in the state, but if the property is not sufficient to satisfy the claim is essentially over because the plaintiff cannot go after the defendant any further beyond the value of the property. Due process comes into an issue here when we're talking about jurisdiction, because certainly if there is a situation where the plaintiff has, or the defendant, I'm sorry, has voluntarily acquiesced to jurisdiction of a state, or when a defendant has established residency in a state, there's really no issue there about whether or not it's proper for the state to assume jurisdiction over that defendant. However, for non-resident defendants who don't consent to jurisdiction, due process is certainly an issue. And that's where the concept of minimum contacts comes in. If the defendant has some contact with the state through an activity that is conducted within the state, then it's fair to impose jurisdiction over that defendant because of those contacts with the state. Keep in mind that the defendants, regardless of the type of jurisdiction, have to receive notice of an action through the service of a complaint and summons, and the long-arm statute comes in allowing that service of a complaint and summons to go across state geographical borders, again depending on the circumstances, the factual circumstances, as to whether or not the defendant can be brought into the state because of some type of activity or minimum contacts. We're talking about comparing the federal adjudication system to the state adjudication system as far as which is better if there's a situation of concurrent jurisdiction and the parties actually have a choice as to whether to litigate their claims in state court or federal court. So generally speaking, state courts are slower because they are more busy, so the time from complaint to trial is longer. In the federal system, there's one judge or magistrate that hears all aspects of the case. In some state courts, multiple judges might be involved in the same litigation. In federal court, the jury pool is larger, coming from multiple counties as opposed to one or two counties in the state court system, at least in Kentucky. Rules of procedure and evidence may be more or less favorable in each of those jurisdictions. And I pointed out one very particular standard as it relates to Civil Rule 56, the rule on summary judgment. In Kentucky, the standard for summary judgment is very high, meaning the likelihood that a party could file a motion for summary judgment and be successful in Kentucky state court is much less likely than the same type of motion that would be filed in federal court. And again, the standard is lower there, so the likelihood that the party filing would be successful on that motion is better in federal court. And some parties, especially defendants, see that as an advantage, as defendants are typically the parties that are going to file those types of motions. So let's talk about the difference once you choose between federal and state court, the different types of trial courts that exist within each of those systems. Generally speaking, there's going to be a court of limited jurisdiction and a court of general jurisdiction in both trial courts, in federal and state. The names that we use for these courts are different. The concepts remain the same. In state court in Kentucky, the trial courts are broken down into district courts and circuit courts. The district courts being the court of limited jurisdiction, meaning only very limited things can be litigated in that court, as opposed to the court of general jurisdiction, which has a much larger subject that can be litigated in that particular court. The federal system is the same, except the names are different, as I alluded to before. In the federal system, the Court of General Jurisdiction is called the U.S. District Court, and the Court of Limited Jurisdiction have specialty names such as tax, patent, and admiralty. Moving on to the discussion of venue. As I said before, venue refers to the geographical location within the state or federal system where the lawsuit will actually be filed. In federal court, Venue is determined under 28 U.S.C. 1391, which says where the defendant resides, where the event occurred, or where any defendant is subject to personal jurisdiction, that is appropriate venue. And venue may be changed if it's improper, if it's inconvenient, or if the parties reach an agreement as to a particular venue. In state court, venue is typically decided by the same concepts, where the plaintiff resides, where the defendant resides, where the event occurred, or where the parties agree to venue. You should know that there are choices of law or forum selection clauses that you might see in a lot of contracts, and these clauses are enforceable by courts, and they dictate where litigation may occur, sometimes specifically as to state versus federal court, and then the venue within each of those systems. Hopefully this helps you get ready for the exam. Remember, the exam allows you to use your notes, anything that I posted on Blackboard, anything from the textbook, or technically any other reliable source that you might find, although I would be very careful about going outside of the materials that have been specifically assigned to you in the course, because I question sometimes reliability of things that you might find out on the internet. You may not work together, however. This is to be turned in on your own and to be your own work. Your exams are due a week from today, which would be Wednesday, February 17th, 2016 at 2:30 for the Bowling Green students and 3:30 for the Elizabethtown students. Again, if you have any questions at all, don't hesitate to give me a call. Everything should be posted and ready for you to go today at 2:30. Good luck.